Hello friends, in the series on the income tax cases, today we will discuss a very important case on section 153A proceedings. In section 153A, the assessment of a person on whom the search has been made before 1st April 2021 is being made. It is a settled law that the addition under section 153A assessment can be made only on the basis of any material found during the course of the search on the assessee, especially in a case when there is no assessment pending on the date of the search. The question before Kolkata ITAT D bench in the present case was that when there is a situation when there is no incriminating material found in the search of the assessee on the basis of which the addition was being made in the case of the assessee, that whether only on the statement of some person M and P whose statements were not even recorded in the search of the assessee and even not told to the assessee that in which proceedings those statements were recorded. So whether in that case the addition made for unsecured loans under section 68 is justified. This issue has been taken up by Honorable Kolkata ITAT D bench in the case of Deputy Commissioner of Income Tax versus Southwinds Project LLP. This case is reported in 124 ITR Tribunal at page number 292 and the date of the judgment is 22nd April 2025. In the present case, the assessment year concerned is 13-14 and the assessee has filed the return at nil income for the assessment year 13-14. There was a search on the assessee and its group companies, due to which the case of the assessee was picked up under section 153A and the learned assessing officer made the addition under section 69A for those unsecured loans. At the same time, the addition under section 69C was made on the presumption that the assessee would have paid 9% interest on those loans, and again on the presumption that for securing these unsecured loans as an accommodation entry, the assessee must have paid 0.5% commission. So there were three additions for unsecured loans under section 68, for interest disallowance under section 69C, for commission paid under section 69C. In the present case, it was undisputed fact that there was no assessment pending at the date of the search, or the time to issue the notice under section 143 subsection 2 was also expired. So it was a case of unabatement of assessments. When the CIT appeal heard the matter, CIT appeal gave relief to the assessee, so the revenue was before the tribunal. And when the tribunal heard the matter, the tribunal said that in the present case, it is a non-abatement case and the time to issue the notice has already expired under section 143 subsection 2. So in the present case, the additions was justified only on the basis of any incriminating material found in the search, since there was no incriminating material related to the securing of the loans which have been unearthed in the search proceedings. So the additions are baseless. The tribunal said that in the present case, the sole basis of making the addition is the statement of M and P, and more interestingly, during the assessment proceedings, those statements were not made available to the assessee, and even it was not told that under which proceedings those statements were recorded. The tribunal said that for the fourth proviso to section 153 broadly talks about that the assessment under section 153A can be made only if some books of accounts have been searched or found in the search proceedings and not in any other proceedings, and there is a clear-cut indication that the undisclosed income is in the form of assets. Only in that case the section 153A will be attracted beyond 6 years. So friends, in this case the assessment was quashed on the sole ground that the addition on the basis of the statement of M and P which were not recorded in the search is baseless. At the end of this video, Once again, I am repeating the name of the case. The name of the case is Deputy Commissioner of Income Tax versus Southwinds Project LLP. This case is reported in 124 ITR Tribunal at page number 292. The matter is decided on 22nd April 2025. Thank you, friends.